Okay, so hello everyone. We are from group 3 and we are going to present about the role of the OECD commentary in tax treaty interpretation. But before we start presenting, we would like to introduce ourselves. Okay, so this is our team. My name is Clarina Altina and my friends Chut Naifa and Carla and also Ruben. Next slide, please. This slide introduces the basic framework of international taxation, and jurisdiction refers to the authority of a state to impose tax on persons or income connected to it. Tax jurisdiction refers to the authority of a state to impose tax on persons or income connected, and they have two principles. The first one is residence, which taxation based on domicile or place of residence, and second one is source principle, where it is based on where the income is generated. And both principles are grounded in sovereignty theory, which views taxation as an expression of state power. However, when multiple states claim taxing rights over the same incomes, conflicts arise, and this can result in double taxation. So to prevent this, countries conclude tax treaties, and these treaties are interpreted according to the Vienna Convention on the Law of Treaties, particularly Article 31 to 33. In practice, treaty interpretation often refers to the OECD Model Convention and its commentary. And this raises an important question, which would be discussed further in the article. How much legal weight should the OECD commentary actually carry? Next slide, please. Okay, so this slide explains that most international tax treaties are based on the OECD Model Convention, accompanied by the OECD commentary, and the model serves as a drafting template or draft treaties, while the commentary explains how treaty provisions should be understood. Because many treaties mirror the OECD model, the commentary has become an important reference in the interpretation. However, since 1992, the OECD model and its commentary have been revised regularly, and this creates a critical question: should amendments to the OECD commentary apply to tax treaties that were concluded before those amendments existed? The OECD Committee on Fiscal Affairs suggests that later amendments often reflect consensus and may apply to earlier treaties. So to properly evaluate this issue, Lang and Brugger turned to international law, specifically the Vienna Convention on the Law of Treaties. Next slide, please. So the author Lang and Berger examines whether the OECD commentary fits within the interpretative framework established by the Vienna Convention. There are three articles. The first one is Article 31, which treaties must be interpreted in good faith. And under 32, supplementary materials may be used only if ambiguity remains. And under Article 31 and 3, subsequent agreements and subsequent practice may influence interpretation. And within this framework, the authors argue several key points. The first one is that the OECD commentary is not legally binding. And the second one is it may serve as a supplementary interpretative aid. However, amendments made after the treaty was concluded cannot automatically reflect the original intention of the contracting states, and later revisions may only play a very limited role, particularly where ambiguity exists or consistent state practice is demonstrated. And frequent provisions also risk undermining legal certainty as it becomes unclear which versions apply, which this article highlights a tension between practical administrative reliance on the OECD commentary and also the legal limits. Next slide, please.
So now let's move on the next part. So in this part, we will explain how the core concepts from our week 3 class are reflected in the article by Lang and Brugger. So first, the article clearly connects to our discussion of tax treaty as coordination tool of tax jurisdiction. In class, we saw that tax treaty operate as lex specialis. that organize how residents and source states share or limit their taxing rights, whether these rights are exclusive, limited, or even relinquished. This article works exactly at this level. It does not calculate tax, but it explains how tax treaty should be interpreted so that this allocation of taxing right is applied correctly. By relying on OECD model and its commentary, the authors show how states try to give common, coordinated, and meaning to treaty provision that govern who can tax which income. Second, the article is closely related to a concept of resident versus source and fiscal allegiance. In week 3, we studied worldwide income based on residence, the source of territorial principle, and also citizenship taxation. We also distinguished between the personal fiscal allegiance, which focused on taxpayers' status residence, and the objective fiscal allegiance, which focuses on the source of income. The article does not redefine those principles, but it shows how they are implemented in practice through treaty interpretation. When courts and tax authorities interpret provision on residence, permanent establishment, and business profits or passive income, they are effectively deciding how far the resident state's worldwide income claim goes and how much taxing power remains the source of state. The use of Vienna Convention and OECD commentary directly shape the concept scope of residence and source taxing right. Third, the article connects to our treatment of permanent establishment and taxable presence. In class, we saw that a permanent establishment, or PE, is treated as a separate tax subject and that it is the key concept for determining when business profit can be taxed in source states. The article takes this further by showing how OECD commentary is used to interpret standardized notion in OECD model, including the definition of a permanent establishment. For example, whether a warehouse, a construction site, or a dependent agent create a PE will often be clarified by referring to substantive concept, and the article showed the interpretative method that determine how that concept is applied to real cases. Finally, the article reflects a broader approach to tax subject and tax object in treaty context. During week 3, we identified individual entities and permanent establishment as tax subject and domestic and foreign source income as tax object. This article operates on a level above this. It explains how tax treaty interpreted with the help of OECD commentary frame the taxation of this subject and object, and in other words, the class tells us who and what can be taxed, while the article explains how we read the treaty rules that distribute the taxing rights over those personal and incomes. Next slide, please.
Okay, so I will be explaining about the theoretical foundation of this article. So Lang and Berger ground their analysis in the Vienna Convention on the Law of Treaties, which provides the legal framework for treaty interpretation, which Article 31 established as the primary rule, where the treaty must be interpreted in a good faith. And also, this confirms that the treaty text remains the primary source of meaning because the OECD commentary is not part of the treaty itself, so it cannot automatically determine the interpretation, and followed with the Article 32, which allows supplementary materials only when Article 31 leaves ambiguity. Within this structure, the OECD commentary may serve as a supplementary interpretative aid where treaty wording particularly where treaty wording mirrors the OECD model. However, its roles remains as secondary and it cannot override clear treaty language. Next, Article 31.3, which later amendments may influence interpretation only if they reflect consistent agreement or practice between states. And Also, the author conclude that the OECD commentary amendments are not automatically binding. Frequent revisions do not necessarily establish a common understanding, and later amendments cannot retroactively determine the original treaty intention. So the key insight in here is that the authority of the OECD commentary is limited by the hierarchy of treaty interpretation under international law, where the treaty text prevails and external guidance remain supportive. Next slide, please.
So now we are going to focus on the key arguments of the article. So the first key argument is that when a tax treaty follows the wording of OECD Model Convention, it is reasonable to presume that the contracting states intended the meaning reflected in the OECD commentary that existed at the time of the negotiation. The authors rely on the general rules of interpretation of Article 31 in Vienna Convention, which requires interpretation in good faith according to ordinary meaning of the terms in their context and light of the object and purpose of the treaty. If two states deliberately copy the exact text of OECD model, it is not realistic to pretend that the model and its commentary are irrelevant. For example, imagine a treaty article on a business profit that reproduces Article 7 of OECD model, almost word for word. If a dispute arises about whether certain consultancy fee qualify as business profit or at royalties, a court will naturally look at the commentary that exists when the treaty was signed to understand how the term of business profit was used and what kind of income it was meant to cover. Then we have also the argument that the OECD commentary, while highly influential, does not have the same legal force as the treaty itself. The treaty is a binding international agreement. The commentary is not. In that situation, the commentary can be used to support an interpretation that fits within the text, but cannot be used to contradict it. This highlights an important hierarchy. First, the treaty text, then the interpretative tools such as the commentary. Third, the article explains in detail how the Vienna Convention on Law for Treaty Structures to use of the OECD commentary. Article 31 proposes general rules, good faith, ordinary meaning, context, and object and purpose. Article 32 allows to use of supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion. When interpretation under Article 31 leaves the meaning ambiguous, obscure, or produce a manifestly absurd or unreasonable result. In this framework, the OECD Model Convention and the commentary can operate at two levels. On one hand, when a treaty clearly follows the model, they can be a part of the context and inform the ordinary meaning in good faith under Article 31. On the other hand, when they can also function as supplementary meaning under Article 32, especially when negotiators actually use the model and commentary during negotiation. A fourth important argument concerns reservation and observation that states make to the OECD model and commentary. OECD members country can enter reservation to provision of the model and observation to particular paragraph of the commentary. This reservation and observation signal that a country does not fully accept the standard of OECD position. As a result, there's interpretative value of the standard commentary is reduced for treaty involving that state. For example, if a country has a reservation on Article 7 and negotiate a treaty that reflects this reservation in the text, the usual commentary on Article 7 cannot be treated as if it perfectly described the common understanding of both states. Similarly, if a country B files an observation disagreeing with a specific paragraph of the commentary on a permanent establishment, that paragraph cannot automatically be used as an evidence of what country B agreed to. In such case, interpreters need to look more carefully at the treaty wording, the negotiation history, and perhaps other material to understand the parties' real intention. Next slide, please. The fifth key argument is about amendments to OECD commentary that are adopted after a tax treaty has been concluded. Since the early 90s, the OECD has updated the model and commentary regularly. The author insists that later version of commentary cannot be used to establish the original common intention of the parties at the time the treaty was signed. They were not available during negotiations, so they cannot be part of the original context. For example, imagine a treaty signed in the 90s and significant change to commentary on abuse of treaties or beneficial ownership in 2003. A tax administration might be tempted to use the 2003 commentary to argue that the treaty always meant to deny treaty benefit in a certain conduct situations. According to the article, this is problematic because in 2010, in 2003, tax cannot retroactively prove what the states really intended in the 90s. And finally, the sixth argument is that later commentary may sometimes be relevant at subsequent practice or through mutual agreement procedure, but only within a narrow limit and always in line with the Vienna Convention. Next slide.
Okay, now we're moving on to the relevance to the OECD commentary. So basically here, the core idea is the OECD commentary serves as the essential interpretive bridge for our key concept here in international taxation. It shows how the OECD commentary clarifies treaty terms that define tax subjects such as individuals, companies, and permanent establishment, and also define tax objects like worldwide income versus Indonesia source income, and also define the important balance between residence and source jurisdiction under Indonesian tax law. And also, the OECD commentary clarifies tax subjects and permanent establishment definition. Example is when a foreign entity creates a fixed place of business such as office, factory, mining site, it will become a separate tax subject in Indonesia that will be under UU rules. And second one is it explains the allocation of taxing rights on tax objects such as royalties, service fees, and branch profit, and also withholding under Chapter 26, which reduce via treaties. And next one is what is the connection between the Vienna Convention? So basically, the Article 31 and Article 32 limit the commentary to a supplementary role, which protects the original treaty intent and legal certainty in Indonesia DTAs. And why is it important to Indonesia? Because OECD commentary could helps the Directorate General of Taxes and also taxpayer to interpret the permanent establishment rules, which also withholding rates and also the double taxation relief consistency in real cases such as foreign doctors, accountants, electric plant, PE, or airline services from the examples. Okay, next slide, please. And now we're moving on to the legal and practical implication of OECD commentary. So on the left side here we have the legal implications. So we could see the clear boundaries set by the Vienna Convention. So first one is Article 31st or the primary rule. So Article 31st requires a good faith interpretation based on the ordinary meaning, context, and purpose of the treaty. This means that we should normally use the commentary version that existed when the treaty was signed. So this is the static approach to protect the original agreement between the two countries and maintain a legal certainty in Indonesian law. And the second one is the Article 32 or the supplementary rule. So basically this article allows us to use the commentary only when there is ambiguity or to confirm an interpretation. Later amendments cannot automatically override clear treaty text or create absurd result unless both countries explicitly agree. So this could limit the ambulatory or constantly evolving approach and ensure stability. And for the practical implication, the tax authorities or DGT will rely on the commentary for audits, PA classification, and also withholding under Chapter 26 and providing consistency in cross-border cases. So taxpayer could benefit from clearer planning for investment or services, but also could face compliance risk if updates blur clarification versus substantive change. For example, if the broader PE scope discouraging foreign activity. So the key takeaway here is the commentary is a vital guide, but the Vienna Convention the Vienna Convention keeps it secondary while prioritizing the treaty tax and stability for fair international taxation in Indonesia. Now, moving on to the next slide.
I will now talk about some of the broader academic and practical context of the paper. So from the academic perspective, the paper makes an important contribution to the debate on the treaty interpretation in international tax law. It situates the tax treaty interpretation by looking at the Vienna Convention on the Law of Treaties. By doing so, it says that tax treaties are public international taxation law instruments and just domestic tax legislation with international elements. The paper also makes a big point about the long-standing debate between a static and a dynamic interpretation of the treaty, because the OECD has argued that later amendments to the OECD commentary should apply to older treaties. They look at it from a more dynamic standpoint. However, the authors of the paper argue that the interpretation must be anchored in the parties' intentions at the time of treaty conclusion, which is a static interpretation. The paper therefore raises questions about the legitimacy and authority in global tax governance. It highlights the tension between flexibility in international tax coordination and legal certainty in treaty obligations. When we look at the practical implications, the paper is highly relevant for courts, for tax administrations, and for taxpayers and multinationals. For courts, the OECD commentary should be persuasive but not binding. Judges must begin with Article 31 of the Vienna Convention and treat the commentary as an interpretative aid, not as a controlling authority. For tax administrations, the paper limits reliance on the latest OECD updates when applied to older treaties. Administrative practice alone cannot rewrite these treaty obligations. For taxpayers and multinationals, the paper supports legal certainty. If what the OECD says will be true, it will create unpredictability in cross-border taxation, but the author's approach would protect stability in international tax planning. Next slide, please. For our conclusions, we have 4 main points. First, the OECD commentary plays an important role in interpreting tax treaties when treaty provisions follow the OECD model. Second, the relevant commentary version is generally the one existing at the time the treaty was concluded. Third, later amendments cannot automatically apply to previously concluded treaties. And finally, the fourth one, frequent revisions of the OECD commentary risk undermining legal certainty and its interpretive authority. In conclusion, the paper defends a careful, legally grounded approach to tax treaty interpretation and states that interpretation of treaties must remain anchored in international law principles rather than in evolving administrative guidance. Next slide, please. Thank you very much for listening to our presentation.